Item 38 to 52. Item 53 to 73. Item 74 to 95. Item 90 to 102. The matter stands and this.
What is the urgency? Sixteen.
Is the last day.
No, Mr. Council.
I did not know. 31st was last day earlier. Well, we were searching before the authorities for getting.
No, Mr. Council.
Minutes,
What is the urgency? Yes.
minutes. May I seek your lordship's indulgence, minutes?
16.
Minutes, I apologize, there is little delay. Minutes, manage item number 38, minutes, I apologize, there was some delay in connection.
Yes, Mr. Council, you can represent when the matter is called. Yes.
Many times also, but also that the matters we today per month. I have to go on them.
10. No more. 15. Next week on the 15th. Yes.
Forest application.
What is the urgency?
Forest application for integrating with the sign lands.
Let the matters come.
This is the registration matter, your lordship. There is a direction to list the matter last week, your lordship, but not listed, your lordship. Kindly.
Yes.
Remember that. It's declared as non-position is not having thinking point of that. You it is declared as a forest plan. It is declared as a forest plan without notice to win. Will be an aspect of it. I think protect as the on
22nd. Yes. What is urgency?
Your lordship.
Going to local
22nd.
Your lordship matters, but only the stamps and registration, your lordship, both are covered matters for registration, pertaining to registration of the document. Kindly have it to your lordship.
What is the urgency?
Your lordship, refuse to.
What is the urgency?
Your lordship, registration for.
22nd. Yes. 22nd. Yes.
Well, this matters, my lord, two matters are admission matters, my lord. It was supposed to post on 10th of October, my lord, but it has been not
22nd. Yes.
number one.
Learned counsel for petitioner states that the writ petition has become unconscious. Recording the submission judgment, writ petition is.
Litigation where the petition is one of 660 square yards and petition number 2 is 121 square yards in survey number 77 by A, Kuruvi Mandal, Kuruvi village lots. Whereas the petition number 1 obtained Nala permission on 31st to 12/2022 and is in the possession of the property. Currently, on 11/1/2023, joint survey has been conducted behind back of the petitioners, and the stone pillars were erected by the respondent number 3, EO of the Kuruvi Mandal, Veerabhadra Swami Temple Miller, against which we have preferred writ petition Millers. The writ petition status quo was granted by the Honorable Court Miller. Indeed, Miller, on next day itself, on two next days, finishing has been finished by the respondent number 3. In spite of Millers, I filed Millers in this page number 57 Millers. Status quo granted, my lord. Thereafter, it has been disposed of, my lord. Honorable Court, by the Honorable Court, my lords. Page number 54, sorry, 57, my lords. Lordship is could see the operative portion, my lords. In page number 62. Page number 62, may I read, my lords? Lordship, please to dispose of the writ petition.
Yes.
The direction to conduct survey. Survey has been conducted. Only particular to 77 survey number only survey was conducted by the surveyor and left the 78 as per the no survey has been conducted in survey number 78. Survey report is not furnished to us, my lord. Only map has been furnished to us, my lord. Map, sketch map is, lords may have seen, my lords. And
Some of our endowments. We called
page
it.
number 64, my lords.
These versions. Writ petition is filed pursuing the action of the respondents. We are not receiving and not registering the statement presented in respect of survey number 275, not the double O below 275 double B. The facts of the case are lost to kindly done. Not these.
Is there any attachment?
Income tax authorities will not give an order of attachment. Lost to kindly done to.
Minutes, I'm appearing for 5 minutes, respondent number 5. Respondent number 5 minutes.
Insurance covered by the agreement of the sample report, page 28. Page 28, we got on 16/7/2010 lawsuits. Where the order of attachment under section 281B was issued. Where in respect of lands, we got mentioned there. Where the loss may kindly see, we got this item 2 million. Kolluru, survey number 178,690 meters. Where the another Kolluru, the survey number 27. These are relevant. The 2010 million. Subsequently, we got the Prasad against whom the attachment order was issued. He had executed a sale deed in favor of the petitioner. A copy of the sale deed I filed with. Thereafter, we were questioning that questioning the attachment order. And also the action of the registering authorities in refusing to register. A writ petition has been filed, that is a page. That page, must be kindly see page 19. Page 19. Page 19. Last week kindly see in the relief survey number 619-170 A6 Kollur village representing 6 set of 19 meters. But this report. Page 22, this report passed in order. Page 22, it starts with page 19. But operator portion, Lakshmi can see para 4.
Yes.
No, paragraph page 22, para 4.
Yes.
The standing council representing the income tax department has stated the attachment order will valid only 6 months.
Millets, I'm verifying that. I'm representing respondent number 5, Millets. I've been just instructed that it falls within the jurisdiction I'm handling. My name may be printed, Sundari RPC Party. Millets, I'll get instructions whether the attachment has been extended. Unfortunately, the officials are slightly caught up with election duty. Lakshmi post it after 2 weeks. I'll get all the information, Millets. If the attachment has been extended, then, if it has not been extended, there's no problem, but I'll verify that, Millets.
The standing council will not then appear as reported this honorable report that it's the validity only for a period of 6 months.
Millets, that will have to be verified.
13 years have been elapsed. 13 years have been elapsed.
Lord, I'm appearing for petitioner number 2 in this case, Lord. In fact, I have also extracted on page number 15, section 281B of the Income Tax Act, which itself says that it cannot be extended beyond 6 months. So now they cannot come and say that it has been extended because the act itself says That cannot be extended. If Lordship may kindly see page number 15, I have extracted the provision of law.
What is your submission in this regard, Amma?
I'm sorry, Millard.
What is your submission in that regard?
Millard, my only submission is, Millard, I've just received the file. I've been told this morning. I'll get the instructions. My name may be printed. Your Lordship may post it next week also. I just need to verify if there is any kind of attachment. Factually, I'll need to verify that, Millard, if the extension has been there.
But day after tomorrow in the motion list also.
Your good name, Amma?
Sundari, Millard. Sundari Arpis Party.
Print the name. Srimati
Sundari.
Sundari.
Yeah.
Page 37. Came party, my lord, yesterday, but plot number 2.
Ask. The industry cooperatives. If 136.
Kindly pass. Kiran, taking advantage of market information.
Where is the judgment?
Relevant for page perspective. Number 5. Without it, it's absence by the independent frequency. Develop by issuing patents. You feel right and but then page number 15 is there is no entry of
There is no entry on.
passing of
Why there should be entry? Under which provision of law?
definition of property.
Under which provision of law there should be an entry?
Sorry.
Under which provision of law there should be an entry? In a specific suit for specific performance, a decree was passed in favor of your client. Is there any provision of law that there should be an entry in the relevant register by the concerned registrar?
Then the provision stands.
Where? What is the provision?
1 week time.
Any further submission? Land counsel for the petitioner seeks to list matter on 8th level. And stand over to 8th level.
Response not registering the memo of deposit of title deed. Land situated at Makta, Mahbubpet village.
Yes, Mr. Counsel.
It's similar and covered over the middle of page.
No question of covered orders after the judgment of the division bench of this court.
Yeah, already page number 9, already stated in the page number 9. 9.
You are referring to the notification that is issued by the collector. And the division bench of this court has clearly stated that the collector is empowered to issue notification. How the writ petition is maintained?
Collector is not issuing any notification, my lord. In this. This is a draft notification. Page number 9 and para number 5, my lord. It will say notification here, endorsement saying that the case been before the commission of appeal, file number so and so, and sumoto revision the cancelling the supplement state or so on. I submitted the honorable court WP number 23574 of 2015 was pleased to synthesize and impute proceedings holding that the appeal does not lie before the commissioner. Against the proceeding, the reverse, the entries of the revenue record and the writ petition was allowed by order dated 17/1/2007. And hence the land is private. Patal.
Yes, Mr. GP.
Already.
Calling for objections, not a notification.
This notification was set aside.
Yes.
Forward order note page number 10.
Writ petition 167. Yes, disposed of, Mr.
Deeply obliged.
May please, Your Worship. Milord, the petitioner presented the agreement of sale cum GPA that has been refused, Milord. Page number 15 is the refusal order.
Page number?
15, Milord, 15. The first paragraph, Milord, the document styled AGPA with possession refused for registration has the scheduled property so and so, so and so. The Honorable High Court of Telangana wide IA number.
Is that order writ petition 28497 of 2000?
Yes, page number, Milord. Page number 33, Milord. This Honorable Court earlier, Milord, granted interim direction not to entertain any registration. Subsequently, Milord, page number 32, that order has been vacated, writ petition has been withdrawn. Page number 32, Milord.
32.
Yes, operative portion.
Yes, Mr. GP. What will verify? Verify with the record. Heard.
Item 16 also similar.
Sri so-and-so.
Page number 15, my lord, refusal order. Much.
Yeah. This is the corresponding the documents under the they actually this property was conveyed to third party. The same server instructed the document. But there was server number was not taken, only door number is. But the city calculated and bank loans are not getting the only because server number is. Instead of quarreling with them.
On what ground they have refused to register your document?
Nothing. They don't say anything.
Yes, Mr. GP.
31 order. You are the order in the page. Forty-four to 47.
That's good. Property description of sufficient evidence. Yes, Mr. Kumar.
14 of safety.
14 into this.
Wait, please, your lordship.
1 minute. Mr.
Yes.
Yes.
Wait, please, your lordships. That petitioner before your lordships, my lord, is the owner of the subject property, having purchased the same in the year 1988. Thereafter, my lord, the property was assessed. Municipal door numbers were allotted. 2 door numbers are allotted, my lord. I have been paying the property tax, my lord, since the date of assessment, my lord, till date. I have filed all the receipts from page 44 to 61. Thereafter, my lord, industries were established. For the personal necessities, my lord, petitioner mortgaged the title deeds with the bank. In the year 2023, in the month of May, we repaid the entire amount. The bank registered released deeds, my lord, in our favor. Now, my lord, we went to register the property in favor of third persons. The third respondent who himself registered the released it in the month of May is now asking for NOC, production of NOC from the bank. Absolutely no authority for him to ask that, your lordships. Since 88, my lord, we are the owners. We are paying the property tax. We mortgaged by way of deposit of title deeds. In the month of May, it was released. There is no meaning, my lord, in asking for NOC. Yes, your lordship. So release deeds are at page number 68 to 75.
Yes, Mr. GP. When the release date was executed and registered, what is the necessity for again producing NOC? Get instruction. Notice for the sufficient flood concept for the petitioner. Notice before admission based.
Oblige.
257. Yes. Cross conference.
Petitioner Lordships, the respondent not refusing the impounding the documents of agreement of sale. Not the Lordship, the petitioner is absolute owner of the property. The land was acquired by the GHMC. The amount was deposited before the CCLA. I have to find the documents before the CCLA. Lordship, the unregistered document is my link document. Two documents are unregistered documents. Not I have to produce before the court. Though they are not impounding. I presented the impounding for the document. Blood. The same is refusing without any reasons. Blood. Page number 12 is made application. Page number 12 Lordships. And set 40 is document. The 64 blood receive the deficient stamp duty and impound the document.
Why there are 3 agreements of sale with regard to this?
Because the link document, blood, this is my sale deed, my purchase my sale deed. 2 link documents are sale deeds, blood. This is agreement of sale. My link documents, blood. This is the documents. The agreement of sale executed.
Where are these documents?
Page number 14, blood. A secondary evidence, blood, I have to produce before the court to receive the evidence. Another document, Lordships. Page number 20. Paid entire sale consideration and deliver the possession. In similar circumstances, Lordships, similar circumstances, Lordships, page number 30. The Lordships, operator position, Lordships, page number 34. Has the order not received the documents for impounding?
How can again an agreement of sale can be executed, Mr. Counsel?
Not-
Basing on an agreement of sale?
No, lad. Subsequently, the registered document is there.
Is it?
But the document not filed, but I state my affidavit, lad. That- Page number 3, lad. Para number 3.
The year 2012,
Yes,
this Zarina Begum, an agreement of sale was executed in favor of Srimati Zarina Begum.
vendor, lad.
Again, Zarina Begum executed an agreement of sale in favor of one Muhammad Begum. Huh?
Yes, lad.
The documents be impounded?
The 2 documents are, lad.
Yes, Mr. G.
My submission, lad. Receive the impounding document for secondary evidence, lad. That is the reason. Receive the document and deficient stamp duty, lad. The Lordships of title will not create.
It's the court itself to send the document for impounding.
But lad, the summary trial is going on, and because what? At least one document, lad. One.
Please before admission, waives notice for all the respondents, seeks time to get in.
The petitioner before Lordship is flat sensitive of 850 square feet or third of part in Mitchell. The registrar, my lord, the second respondent refused to accept the sale deed. And they want to transfer the property they have purchased in 2002 month. Family also rather they want to sell the property.
Yes, Mr. GP.
It's a covered matter, my lord. Lordship will pass the same order, my lord.
Last
71.
Yes. Beg to represent your lordship. Respondent number 3 is not receiving lead stream between the document presented by the applicant, your lordship. This matter relates to CMA and OS suits matter, your lordship. Your lordship already page 5. Yes, Mr. GP. Please.
Petition filed on the ground that they are said land is part and parcel of the original forest land. Whereas the Panchnama was conducted at page number 46, the English translation, and page number 48. There is clearly 10 acre 39 gutta in largely at same land. And moreover, this is 73 square yard of land in shape. Is the subject matter of the petition. It is not included in the notification of prohibitions. Merely saying your lordship can see.
Where is your document?
Actually, page number
43 E5. Mr. Townsend, so far as the land in survey number 243 E5 is concerned, there is a letter of the district collector.
Letter of district collector is there, but Pachnama was conducted, it is not so. It was a their area. It was divided into two. That one three.
Where is that letter?
Is page number 46. Panchnama is there. On the application of my vendor, it has been the our three mediators have been page number 48.
Where is the letter of the district collector, Mr. Council?
I do not.
Or this is also
Notification on
let us. Let them file their counter. Let them file their counter. Yes, Mr. GP. Yes, madam.
But matter pertains to respond number 3, which registering I said it for this, which is found on page number 18. So actually, has been discussed. Cover matter. Page number 61 is.
Where is the refusal order?
Page number 18.
Yes, Mr. GP. That's a set of the order in petition.
May I please? Is the writ petition of lordship filed against the action of the respondent number 5 in non-undertaking the registration on the land of the Patta land of the petition of lordship. Kindly see the page number 13,
Mr. Chief.
20 and 21. 21 also same alert. Item 5 also same alert. Same village, same survey number.
5 foot. What is the document you attempted to produce?
Patta passbook is there, lordship. Latest.
What is the document? Is it a sale deed?
It's an ancestral property, lordship, since
What document you attempted to produce before the registering authority?
Patta, Patta passbook.
Council.
There is no document.
Which document you attempted to produce before the registering authority?
I approached the revenue authority, your lordship, and requested to entertain, book this slot, your lordship,
For what?
to register my land on the name of
Is that what? Is it a sale deed, mortgage deed? What is the deed?
sale deed, your lordship.
Sale deed. Sale deed. Item number 5.
Deep level list.
Millard, I beg to represent Gangadhar. The petitioner is filed to receive and release the document, register the document, Millard. The petitioner earlier filed the writ petition 37378 of 23, Millard, at page 29, Millard. The only thing is, Millard, the sub-register name was wrongly mentioned, Millard. Instead of Gangadhara, they mentioned sub-register Karimnagar, Millard. When they approached the petitioner, approached the registrar, Millard, he insisted for invoicing from sub-register Karimnagar, Millard. That is the only reason. Already order is there, Millard, page 39. Same survey number, same petitioner. 71 order was issued, Millard, in that.
Why second writ petition?
Millard, this sub-register now, by virtue of district bifurcation, Millard, the land falls under sub-register Gangadhara, Millard. Jurisdiction.
You have to get the petition amended.
So I filed the petition.
We cannot entertain.
Millard, they are insisting NOC, Millard. We approached the Karimnagar, Millard.
You did not state that they insisted NOC.
Millard, I mentioned the affidavit, Millard. I mentioned in the affidavit, Millard. But kindly, Millard, page 2, para 3, Millard. Line 4, Millard. Respondent number 4, Irene along with the purchaser and put a rough draft of the verification. At the time of respondent number 4, clearly stated. Millard, I mentioned in favor of the.
Mr. Counsel, why you have not taken such a plea in the earlier writ petition?
No, Millard. Earlier writ petition, it was it allowed and 71 order, Millard. With that order, we approached the Karimnagar sub-register, Millard. Now Karimnagar sub-register is saying that this jurisdiction is falls under sub-register Gangadhara. So you get a NOC from the Karimnagar sub-register.
Why?
That's what they are insisting. I mentioned in Millard.
Even then you have to make an application in the same writ petition.
I'm seeking same order. So already order is there.
We cannot grant any order.
That. Liberty here.
With a liberty to move an appropriate application.
In the petition number.
Granting such liberty.
It is said by the petition that proceeding the award parts to the Cover other files, page number 21 to 26. That's 7 days and that we have to say.
How do you say that he has no jurisdiction?
No document that they exist. And the similar, there are some that we have been filed. We have been filed in a file.
You say that this person who passed the award has no jurisdiction to entertain the deputy registrar.
No notification has been issued in the name of.
Let us see. Let us see. Heard the submission from counsel for the petitioner.
I'm pretty sure. Pretty good. It's pretty good. But then, you know, that, you know, if that is a member which started. Or I find it application for the amendment. I'm not seeking it. Take page 21, page 21 of it. Repetition. Page 20. It's all of the end of its time.
Page 21 of the petition. Yes. Paragraph.
Paragraph 8.
Page number 21, it is paragraph 11.
Repetition.
You are referring to writ petition. Yes, writ petition. Page? Yes.
I request the occupied consideration of 8.1. Just, you know, paragraph B, that's some paragraph B. In financial reports and petitions for argument security. We can continue without the commission. We need to the intent of charges, which was actually taken in favor of the market.
Yes.
In favor of the market. Why this tribunal, the federal chapter, that the 7/11/2018 is not like there are 17/11/2007. As again, finally, only aspect related to the amendment of 2011 was quantification of the class. But this aspect was not subject to I have not, it's not a. What you could say, what the change of the says. So, but the use of the operation that
Yes.
as adjudicated by this tribunal, the government tribunal.
Yes.
High Court has also considered. And Supreme Court has also considered. That identified. Neither this is not that. This is not the issue before the tribunal.
And this statement is observed, is finding factually incorrect. Number one, endowment tribunal is not considered. Neither import as activity. Now Supreme Court is activity. Three courts never activity, but sometimes the chairman, the tribunal passes an order that identifies. This finding is contrary to not only Central order, Prime Plot, and High Court and Supreme. Then I see finding. But I should have spent page 26. Page 26 of continuation. Paragraph 20. Paragraph 20. You have one paragraph.
Paragraph 12.
Paragraph 20, page 26. Paragraph.
Yes.
But after giving that four lines of the paragraph, and the lines start like this. This tribunal not this tribunal is of the considered that the entitlement and the sharing of documentation character. Even the petitioner, after the eviction is already has attained finality, which has also been affirmed by different of this order of the Honorable Court of India. That will be number so and so. And dated so and so. And also confirmed by Honorable Supreme Court, seal of bill number so and so, as indicated. And leaving about 4 or 5 lines, again I will invite to rush to the intention. Last week, I did get one section about user occupation up to pay evacuation. What the tribunal said. So that the instant occupation tax, entitlement of instant occupation has been decided by the tribunal and the State Court and Supreme. But it was not decided by the tribunal, not decided by the court, not adverted that this issue was debated by the Supreme. The only I thought was saying that they find an unfit for user occupation tax. The tribunal knows of the time. You go and file civil court an application for, well, again in that matter, the matter was static in Supreme Court. Reason in charge will also translate page number. The reason in charge at page number 43. Page number 40. See, at page number 49, paragraph 30. Paragraph 30. Page number 49. Children bench order starts at page number 1. But I want to your paragraph, page number 49. Paragraph 30.
Yes.
But where the platform, they filed application on different operation time. But that was rejected by the tribunal by saying the application was closed. That there is no degree. Again, and that the respondent number 2. By the section that number 800 reports are reports. What was the petition filed by the exam that is best. Limited question that range in the regulations that regard rejection of application of the petitioner under section 83 by the act by the tribunal, the orders of interpreted application. The IJ number 2 of 2010 is OM for so and so path, even by this code is also.
Yes, Mr. Counsel, what happened after the orders in IA-2 of 2010 were set aside and the matter was remitted to the tribunal? What happened thereafter?
Not the orders, that's after the story of the IA. The tribunal said we can't go to civil court. With that observation, IA was closed. Again, the trust fund reputation. They say the division bench says at page 51.
No, Mr. Counsel, the division bench had set aside the order in IA-2 of 2010. Thereafter, the matter was remanded back to the tribunal. Then, after that, what happened?
Back to Supreme Court. Supreme Court said Supreme Court without Supreme Court without deciding, they have not decided it. We have filed this against this portion of the order. We have filed an appeal. Appeal simply was dismissed. And insert dismissal of that appeal. And I request page 51 at paragraph 80. We therefore set aside the improved order 19. 2.
Yes.
2 of 2000. Remit the unpaid to the private for fresh consideration, that is very important. And adjudication in accordance with that. Both the parties can have reverted to be in support of their respective claims. The trial is beginning. And thereafter, tribunal should decide quantum of damage payable by LSC, usual documentation of the property to which trade is setting. May proceeding and a security. This is what she said. Decided in accordance with after application of this. So, the accordance with so this paragraph, dismissal of the sentiments, this paragraph is identified. But we are not educated in our amendment of feelings about this issue. And I did not say that even of I came to finance. I did not give by repetition by paragraph. I raised it up with your person. But I feel page number 9 of the question. Paragraph 2. Paragraph 9, page 9. Paragraph, last 4 lines. The lines start. The first correspondent paragraph.
Page number?
Sir, page 9.
Oh.
Oh. On the last 4 lines.
Yes.
These sentence starts like this. The first correspondent paragraph. Last 4 lines. The first correspondent paragraph. Right of that.
Oh. Yes.
The first respondent writes.
Dismiss the application.
Dismiss the application on the ground. The payment of instant occupation charge to the respondent was attributed in favor of the respondent number 6 by the tribunal on 17 July 2007 and same again penalty. The 11th paragraph improved order of the tribunal is as follows.
Yes.
The Pariputra of enforcement statement of the Honorable Supreme Court. Brings it away. The entitlement of not occupation charges. So that here was small number 3 by the tribunal make it so and so and the claim finance and it's active. And only was contributed to the doctor. Then the page the tribunal in the considered next the tribunal in the considered that the entitlement was during documenting against the petitioner in favor of the eviction order so identified.
Your contention may be true, Mr. Counsel. You filed this writ petition agreed by an order where your plea for submitting additional documents was rejected by the additional pleadings.
I have not stated about this aspect is concerned.
So the writ petition was dismissed.
Yes. Now, the application for dismissal
Thereafter, you filed a writ petition.
That it was dismissed, but I have also examined this portion of the paragraph. That's why I'm inviting the person, only after today's application, you are asking us to regard the opinion of this. I'm not seeking the review of the Russian dismissal order. This is the information as a file. I think we can't thank the Russian regarded review. I'm challenging the information. The writer statement, they're according to booking the that's not
Where is your? Yes, Mr. Counsel, look at your prayer in the writ petition. Then
prayer for repetition. Page 1.
12.
The airport is ordered for this issue across India. Particularly that is for land that was date on the advance subsequent 20 grants.
Yes.
And after that by sending also. So therefore,
You did not seek anything in respect of that observation.
the observation that I have challenged are observation expression. The portion of the output
You did not seek any relief from this court with regard to the set observation. You did not ask to set aside that observation.
and you are supposed this you can bring that down. Really, that's an art. Same also, your husband has experiences. Every aspect will not pray. Really, we say, order has to be set aside. Even take the ground. So you are supposed to regard the finding this letter, never done. Until the law, until the order of Supreme Court.
Yes.
And I read the imperative. See, if you have not disputed, you are also bound to find by the respondent. This is the out of point with us.
ఏదో మన దగ్గర లేదా కౌంటింగ్ మన దగ్గర లేదా
But also.
రివ్యూ అప్లికేషన్ లో కౌంట్ చేశారు.
The paragraph point.
Yes.
Paragraph point. We found. As regards the initiation paragraph of the international, he submitted that the contribution and the petition have no relevance to anybody in have so specifically acted. I have disputed that. Paragraph 6. Paragraph.
Yes. Yes, Mr. Counsel.
Paragraph. As regards to the amendment, paragraph 13 and 14 and the period. It is submitted that there is no perversity. Stated so, categorically, the findings recorded by finding is incorrect, factually incorrect.
Yes.
And so therefore, the observation of the finding that since the practice, I thought CBC will also applicable in repetition. So as far as practice.
Yes.
We will break to set aside our part. The grounds we have considered are I have stated the ground. If the respondent is not disputed, apart from that, whether they are disputed or not, but the order of the court and Supreme Court, let them invite that Supreme Court has said what tribunal said, Supreme Court and then Supreme Court and another reason, your lordship has correct some. That was not the mistake. You are also in page, certificate copy condition. Page
Page
page 4.
4. Yes.
After B line.
Yes.
We're also sorry.
Yes.
Yes. But fourth line, fifth line.
Mm.
A year number 2 of 2008 towards use and occupation tax. These things, not given. I will say, the present is fine. Then senior counsel further continued that substantial amount was paid during the pregnancy in the year. Of course, the given occupation tax, given occupation tax, not to be said. I have stated these things. What you are supposed to support actually is said. Mistake has to be considered these things, but not in the occupation. Use and occupation tax has not been said. Only during the pregnancy of the year. You know, reasons. That has to be factored in. The observation, department when planning. As you record the options, you say that it's the correct time you take that. This is a requisition I'm not saying. You should be sent a requisition is okay. But so far as that finding is not correct, but it's so much not okay. You also go, the department saying, yes, I'm coming to yes, the opinion department, the tribunal is not granted to judgment of high court and something, but that you also say. I'm only coming before this court on that one. Not review of the judgment. Discussion of the judgment for all practical. The finding regarded by the tribunal say in the tribunal putting the amount of the High Court and Supreme Court. Considering of the judgments of the judgment at Supreme Court. That is the what High Court has said. Or Supreme Court has said that is solvent.
Yes. On respondent side.
May it please your lordships. The revision petition, sorry, the writ petition. All the submissions made by the counsel for the petitioner. Lord, now it's okay for you? Lord, all the submissions made by the writ petitioner when the matter came were considered elaborately by your lordships. Kindly see the order passed by your lordships. That is at page 7 of the Lord the review petition and therefore all these submissions made were scrupulously considered. Kindly see, my lord, the way I think your lordships have dealt with this matter. Such an elaborate way that was dictated by your lordships in the open court, this order. Ultimately, your lordships considered all these aspects and then my lord disposed of the matter. Now the review is to be filed, or is filed rather. Kindly see the grounds, my lord, at page 5. These are the grounds. 2 grounds are raised. Prior to that, I'll just take your lordships for once, my lord. One second. Let us see the act, my lord. I read the act also. Section 83(6), under which, my lord, IA2 was filed. Section 83(6). I read to your lordships and your lordships are also pleased to. 83(6), my lord. I said just in a suit, my lord, mean profit, they are all generally sought for along with this prayer. So far, this act is special enactment. It says that once an encroacher is held, once the court holds him to be an encroacher, he was held to be an encroacher. There is no dispute about it by the tribunal order itself. and during the pendency of the proceedings, my lord, we are entitled for use and occupation. IA2 was filed only for use and occupation. Kindly see. This is IA2 now. This has to be disposed of now in the light of the order of the High Court, as confirmed by the Supreme. That's what the trial court, that is tribunal, said, and your lordships were simply pleased to confirm that order. Kindly see let us read the section for once again, my lord. 83(6). IA2 is filed under this during the pendency of the proceedings. IA2 of 2010. In fact, the OA was filed in 2008. OA 21 of 2008, which was renumbered as OA 579 of 2010. And pending that OA, because it was already determined, we go to the tribunal saying is an encroacher, saying that the lease stands determined, and also by virtue of section 82 of the Act, because it's an agricultural land, the lease became null and void, because that's what the Act says. So on both counts, my lord, the tribunal was pleased to hold that he has to be evicted. Then in that, IA2 of 2010 was filed under this clause 83(6). Clause 6 of section 83. Subsection, I put it. Subsection 6, kindly see. During the pendency of the proceedings, the endowment tribunal shall order the encroacher, kindly see this, shall order the encroacher to deposit such amount as may be specified by it in consideration of the use and occupation of the properties in question in the manner prescribed. Now, what the tribunal has done is, having held that he is an encroacher, so far as this IA2 is concerned, the tribunal said go before the civil court and have it adjudicated, against which we filed the writ petition, independent writ petition. Both were disposed of, whatever the lessee had filed it, both were disposed of. Now the High Court has given this direction. So let us read the directions of the High Court, which I think my learned friend has also read. It shall be, just let us have a look at that. Now your lordships have seen. Now, my lord, now it has to be adjudicated in the light of the order of the High Court. Now now the matter was disposed of. He filed an application for permitting him to file an additional counter. Then, my lord, I think it was rejected by the tribunal, sorry. And then your lordships were pleased to confirm it. All the aspects were dealt with. Now a review petition is filed for a kind of a roving inquiry into the aspects, my lord. Once again, kindly see this review petition now. This review petition has no bona fides, my lord, in my humble submission. To say that this point, kindly see what it says, page 5. Is it a ground for review, my lord? My lord, it is settled law that there is only when there is an error apparent in the face of the record does it warrant a review, my lord. There is absolutely no error on the face of the record, according to me. It's a well-considered judgment. Kindly see at page 5, 2 grounds are raised. First ground, it is submitted. The learned endowment tribunal, I think learned, my lord, I think my learned friend is giving credence to the tribunal that way. Recorded the finding regarding entitlement of use and occupation charges as decided by the tribunal, High Court and Supreme Court, and the same has attained finality, and only remains the quantification of amounts. The said finding is factually incorrect and contrary to the judgment of this honorable court, and the honorable court, and the same is perverse in nature. There was no ground raised saying that there is any perversity in the order. Kindly see, your lordships may kindly see the order passed by your lord. It is not contended that there is any perversity in the order of the tribunal. Now suddenly we cannot say there is some perversity in the order of the tribunal. This is something that is beyond the purview of a review petition. Kindly see the next very important, my lord. This said ground was raised in the writ petition. Kindly see this. And made submissions during the course of hearing. What kind of submissions you have made on this? You cannot have a review, my lord, on a aspect on this kind of what made submissions, what kind of submissions are made on this aspect of the matter. There is no reference that there is any perversity in the matter. If there is such an argument, your lordships will have definitely referred to that. There is no perversity in the order. There is not, never contended. And so far as the entitlement is concerned, it flows from the, my lord, from section 83(6). And one more submission here. Kindly take up the, my lord, how the tribunal that is impugned order in the writ petition. Kindly see, my lord, at page, they have extracted, kindly see, my lord, page 18 of the writ petition order. Page 18, paragraph 6. The record further demonstrates that on 17/9/2011, this tribunal has allowed OA number so and so and directed the petitioners to vacate and hand over the scheduled property within 3 months from the date of, failing which directions are issued for recovery of possession by the applicants. By a separate common order dated so and so, the tribunal has also issued various directions which are hereunder. Quote, first it's kindly see this, my lord, that the respondents are liable to pay damages. That the respondents are liable to pay damages for use and occupation, more particularly to decide the period covered by the scope of the petition. And to say that it has not attained finality, again I am asking for that in the review petition, is beyond the scope, my lord. IA2, my lord, was decided to go before the civil court. Then the High Court, now the High Court has, now, my lord, the entire, my lord, the inquiry is as directed by the High Court. Kindly see the order of the High Court for once, my lord. This inquiry now that's going on into the IA2 now is within, my lord, scope of order of the High Court only. We have not, nobody can contravene the order of the High Court. Kindly see the order of the High Court at page, my lord, order of the High Court. Just see, sorry. Order of the High Court. This is at page, division bench order, my lord. Page, my lord, this is writ petition, page 43, it starts. The operative portion is at page 51. Yes, let them lead evidence on this. Both with set aside the impugned order of the tribunal IA2, that is IA2 is go before the civil court for ascertainment of this one, the damage use and occupation charges, and remit the said IA. IA is remitted to the tribunal, that is for payment of use and occupation charges for fresh consideration adjudicate in accordance with the law. Both the parties shall have liberty to lead evidence. Let him lead evidence. Nobody. It is not his case, my lord, that there is any violation of this order. He is trying to read something beyond the scope of the, my lord, the writ petition, your lordship. And the second ground, your lordship will kindly see. And kindly see, my lord, what does it say? The said ground was raised in the writ petition and made submissions in the course of hearing. What is the submission you have made? No submission was made on this. Now suddenly you can't come in review petition saying that some submission. What some submission? We are a review petition. It's a serious matter. To say that your lordship's order has to be reviewed, it is a, I think review is a very serious. Only error apparent. What is the error apparent in the face of the record of your lordships? Let him point out one error. Where is the, what is the error? This order is there. In the entire argument that are advanced, your lordship's order starts at 7. And my lord concludes at page 25. 1 minute, page 26. What is the error of in the order passed by your lord? Kindly see, my lord, there is no error according to me. Everything, 1 minute, sir. You're a senior counsel, I've been an advocate general. Now, let me complete my, no, my learned friend. See, I put it.
Again, the senior counsel.
I never commented against you. I never argued, I commented against you. No. Don't interrupt me, I said.
I will interrupt.
Then let me.
I'm saying.
Against you, but I have all the regard for you.
What regards you are?
No. All right, my lord. I was trying to say page 77 to page 25 is your lordship's order. There is no error apparent in the face of the record. Did not, there is no error committed. That's what is your lordship's order. Now the second ground that is sought to be raised, that is raised in the review petition, kindly see, my lord. Just see. What he says is, second ground is on second ground. In para 4 of the order, this is how he is trying to point out. Typographical mistake is crept in as use and occupation. Our petition itself is for use and occupation. The question of paying of rents subsequent to the determination of lease does not arise. Our petition itself for use and occupation charges. In paragraph 4, your lordship said whatever is paid towards use and occupation charges, as rightly held by the tribunal, whatever is paid towards that, that will be adjusted. What we use and the occupant charges, how can it be replaced as lease rents, my lord? Use and occupant charges have got a different connotation altogether. He wants to convert it as rent, which is 50,000 rupees for about 540 acres. And then wants to say that towards use and occupation charges, he will like to pay only 50,000 per annum in respect of 560 acres. That is not the, my lord, object of the petition or object of the act. My submission to your lordship is, it is only use and occupation charges rightly observed by your lordship. A petition itself is for that. Any amounts, my lord, are paid. That's what the trial tribunal said, and your lordship confirmed it. It is not a case for review in any view of the matter, my lord. My humble submission is, it may kindly be dismissed.
I read that same farmers. The farmers typically farmers might be a I have said farmer. It really farmers. Suppose somebody said, I won't building here won't see or in the won't see you get that. It's backed by you. It's the same thing somebody said. The High Court building is deeply that is part of that. So therefore, from our side, I am saying today, the high challenge that observations are finally regarded by the private. Tribunal said, tribunal should put it that finding in the amount of legal mechanism. That's supreme. My submission before the Sun would be that either this High Court or the tribunal are not decided that. That is it. It's the order before. Then the Supreme Court said, or it was 1982 Supreme Court. State of Maharashtra. It was a kindly vote, I will pass it. 1982 Supreme Court to party. What Supreme Court earlier three courts of faith. But any mistakes are categorical. Our omissions are any. Suppose council argued against or active in the by council should argue at length by sometimes hours to get it. Previously used to buy a synapse of submission. That was not there now, arguing the rules. But any finding or an omission is. But council has to bring the notice to the board. That bring the notice of the by way of application. By way of application, for our practice, our own practice for behavior. That's what. The second practice is for an application review. What review? I am making my submission to your time inspection. I am not challenging about some of the dismissal of the request. So whatever I am challenging, the tribunal finding I have made that that was not considered. That only you are supposed to correct. What I am saying, but you are supposed to direct the tribunal without reference to the finding. Tribunal will dispose of the application. Because that finding is itself contrary to Supreme Court. That I believe what Supreme Court said.
CPC fiscal.
Or you ask me, no paragraph.
Forward the copy of the decision, Mr.
Yes,
Speaker.
I will read. Facts of the case in one. Then we draw the attention to the law written within that. Concession made before the High Court so appeared a state of Maharashtra before the High Court. Get the argument of the respondent. There appears so and so, an interview and invited parties attend submission made by him. In that we are afraid we cannot launch it with inquiry what was transferred. Simply it is not. The public policy bars and judicial decorum space matters of judicial department are questioned. They are not open to debate. What we found to accept the statement of justice. What they say, in the conclusion, the facts stated one of the contents. And if the party thinks the happenings in the course of the wrongly department, and it is incumbent upon the party, while the matter still affects the minds of judges, far attention to the judges who have made a record that bad statement. We learned judges said Mr. Chinnabarati, he has recorded earlier Supreme Court. What I'm saying, the application by the party is not even on the protection. This is my question about but reason that only those things are not very much. You understand? Say without one thing, I am submitting my submission to any suggestion. The findings regards by private acknowledgement without fighting. Then determine number two. Suppose Russians whatever the findings I am telling you today, his endowments trying to find this in your Rashtra. I want to endure your assignments. Your findings are not there. Actually incorrect. And this is purpose. I walk through the
Endowments from the Department of Endowments, any submission? God, Sri, so
but they have not understood that. It will be
learned.
respondent.
Oh, up to down. Yes, Mr. Counsel.
Page number 33.
We'll have it tomorrow. We'll have it tomorrow. Then GP says he is handicapped with the hand.
Yes.
But request of learn GP list on deputy case 25. Posted to tomorrow.
What?
This is 2011 matter, Mr. Counsel. How can it be 2 weeks? Renewal of the practice as notary of the year 2011. How the cast survives? Huh? Land counsel for the petitioner seeks time to verify whether the cast has.
Interim order for bathroom. If you call it lower terms of the purchase may record the order.
Yes, Mr. GP. So we'll close the proceedings. Third, is also London counsel for the petitioner.
I beg to represent G. Rajkumar. A connecting matter is coming up on 20th of this month. Kindly take along with that.
What is the connected matter?
I have no instructions.
This is 2014 matter, Mr. Counsel.
Senior is arguing on this matter.
Led counsel for the petitioner seeks time to give fair opportunity this term.
Petition is filed, madam, last entertaining there is LD. On the ground, my lord, there is an injunction from the court. Court said, my lord, only any elevation is subject to result of this. The last time I submitted, my lord. Any subject to result of the OA, they are ready to abide by the, they made application also. Lordship said, my lord, subject to result of the OA, let them register. Facts of the case, my lord. One Mrs. Qasim B is the owner of 1 acre 30 guntas of land, under having purchased it under sale.
Yes.
Her husband purchased 8 acres of land, my lord, under sale. Last time itself, my lord.
Why you have not filed your counter yet? Huh? That cannot be
Right off in forfeited, my lord, last occasion itself.
Make your submissions on where it's already heard on your side, Mr.
Yes,
Counsel. We'll grant 1 week time. If you want to file counter, you file counter and argue. We cannot grant further time. Learned. AGP for stamps and registration seeks further time to make his up.
Minister said, security this one so that 10 gundas should be in this area. In fact, it is in the gundas. Because that's an act, right? We also said subunits are like the gundas. Slope for 10 10 square yards.
What is the modification you require in the
Slope for 10 gundas, 10 square yards.
where?
So I'll mention in the petition. Petition portion.
So where is your petition?
It's the order, first page of the order. First page of the order.
First page of the order.
Para number 1 of the order. Line 12. An extent of 10 guntas may be replaced with an extent of.
Where is the order, Mr. Counsel?
Already within page number. Are being mentioned. Material paper, page number 1. This is the petition portion, my lord. Which can be C12. Consequently, direct the respondent to receive and process register the documents submitted to the petitioner with respect of land bearing survey number 100 to an extent of 10 guntas.
You have mentioned 10 guntas in your petition.
Yeah, so that now they say that the land is outside and registered non-registered if it is in guntas, and they say that there 10 square yards.
So 10 guntas is equal to 10 square yards. So we'll give an order. Tomorrow he said it should be in meters.
But he says that agricultural land is.
No, Mr. Counsel, this cannot be entertained. Trust me. Learn counsel, but the petitioner seek.
Please to dispose of H8 of IS3 not take of IS.
Yes.
Right, amendment last time quite a paying. There's a correction, there's an error on my side method. That is the reason I tried with IS3. In the main order, there is no error. In the governing docket, page 9, my lord.
What is the error?
But hardship may go to. My lord, page 10, my lord, page 10. Lot number 160, location is circle number 5 by 3, and within 350 yards. This is the correct schedule, my lord. Even in the front say or invitation, the number mentioned is correct. In the order also, but whereas in the docket of the order, my lord, page 9, plot number.
Page 9. Page 9 now?
A3. Here, my lord, because of this variation, my lord, page 9 of the IA3, the house number and the square yards are spelled wrongly, my lord. Whereas in page 10, my lord, it is correct, my lord.
What is the correct one?
Correct number is, my lord, at page 10, it's, plot number 163, survey number 5 by 3, admission 350 yards.
Oh, same is mentioned at page 8 also.
Yes, my lord, but in IA part, my lord, the main is mentioned, that is the reason may not have correct.
What is the operative portion of the order, Mr. Counsel?
Well, an operative portion starts from page 10, my lord. I agree.
At page 13. It is mentioned as plot number 163 located in survey. And then?
But actually, I see IA3, I find that page 9, docket method. Here is a small section. The IA, the number was.
This order was not rendered in IA. This order is rendered in the main writ petition.
Yes.
Then?
But the solicitor is not accepting.
Let him pass in the speaking order. Then we'll pass orders. No need of correcting anything.
But
IA 3 of 2023. This petition is filed seeking for
Lords, I recant on behalf of him. Yesterday, I have made a mention that the Honorable Court has closed my evidence and have filed a petition for reopen. That petition was returned, my lord, on the ground that the docket order was not uploaded. Lord, may kindly post it on any other day so that the docket order may be uploaded and I have get this IA numbered.
So can we post this matter after elections so that it will become infructuous? What is this, Mr. Counsel? Matter election petition of the year 2000.
No, the only reason for
Disposed of within 6 months.
the only reason for not numbering is the docket orders were not uploaded. That is the only reason.
Which order was not uploaded?
That 311 order, ma'am. 311 order of closing the evidence. Closing of petitioner's evidence. Lord, may kindly.
Court officer says it will not be uploaded.
No, the section is taking the objection that without that order that can't be numbered.
Where is your petition?
Yeah, ma'am.
Please come. Is any counter? Then counsel for the petitioner submits that he moved an interlocutory application for reopening the evidence of the copies. Next.
May it please your honor. Item number 35, Miller.
Yes.
Miller, kindly process next week, Miller.
This is listed under the caption for dismissal, Mr. Counsel.
Miller, last occasion I am unable to attend this court, Miller, due to network problem, Miller. Now I am in AP High Court, Miller. Kindly be posted next week, Miller.
Then counsel for the petitioner seeks time.
Next week, Miller.
I beg to appear on behalf of the petitioner, my lords. Several occasions they have taken time to file their counter. My lords, my only difficulty is, my lords. First writ petition has been filed, my lords. WP number 11989. In this, suspension order has already been passed, my lords. Thereafter, another writ petition where the brothers of the petitioners in WP 11989 had filed another writ petition. Suspension orders similar have been passed. But, my lords, a status quo wherein no transactions are to be taken place has been passed. Several occasions they have taken time.
Already we said that no further time will be granted. Huh? What can we do?
My lords, my only prayer is, my lords, limited to the extent that the order may be modified wherein no further transactions are to be taken place. May be changed, my lords. Or else I'm ready for the hearing, my lords.
The GP for endowment seeks further time to file counter. Yes, Mr. Counsel.
I'm representing B. Anantramani. Recently, we have filed Vakalat and
What about service of notice upon respondents 4 and 5? You are appealing to?
respondent. I'm representing B. Anantramani. Requested for 2
You
weeks.
are appealing for which of the respondent?
One of the respondent.
తీసుకొని వకాలత్ తీసు. Then 5 of it.
On 111, Vakalat is filed.
ఇప్పుడు ఇంటికి వచ్చిందా Yes, Mr. Counsel, to whom you are appearing?
I am representing B. Hanmantrao.
For whom he is appearing?
Respondent.
Which of the respondents?
Fourth respondent. I'm not aware, but I'll accept in Lakshmi kindly have after 2 weeks, madam. Recently we have filed Vakaraj.
Sri so and so. Lord Counsel who is representing Sri V. Hanumantarao submits it.
Oh, please. Document has been, the sale deed has been presented. That has been refused, my lord, on the pretext that, my lord, the district collector has addressed a letter. Yes, my lord, I have filed it, my lord, IA number 2 of 2023. Leave petition has been filed to receive the additional document. Page 5 is the refusal order. The middle. The first paragraph is the description, my lord. In the middle paragraph, my lord, permitted to read out.
Yes, Mr. JP. Ask me.
Your lordship. Order copy has been filed, my lord, 56.
A2 of 2025. Heard. The petition is ordered. ఇది చేసింది
Bless.
Yes.
The same situation was paid $73 for the same survey numbers. Issue for the same doesn't random based $70 order. They order the 74 from the same survey numbers.
Hold on, Mr. Counsel.
From same layout, same survey, branded layout partners. Just permitted the operating function in the future. But they call them the minister for the same server numbers. 5, 6, 7, 10 numbers, Five, 6, 7, 10, 11. Upstream of the branded. So your fault. I have filed for 15.
What happened to this writ petition? Where interim order was issued? Then how can we grant interim orders after interim orders, Mr. Counsel, without final disposal? Let them get instructions. Mr. Counsel, it has come for the first time on 13/10. As per writ rules, they'll be having 6 months to file counter. Huh? No. Yes.
6 months.
Or they heard the submission from counsel for the petition and bit.
Number 36 and 37, which is already concluded. Interim orders have to be extended, my lords. Interim orders are that too.
We submitted to
From counsel for the petitioner, 6 times. Hence list on 6.
Slot is given. For registration slot is given.
For 30, slot is given. They can extend.
The injection order is there, extended.
Let us see, Mr. Counsel. List on 10/11. Yes. 10 posted to 10. Yes.
Lordship, the refusal order. So petitioner has submitted the application before the sub-registrar officer, Kukatpalli, Medchal, Malkajgiri, 42, 44, 45, 46, same survey number, same Huda approved layout, my lordship. Petitioners are different, my lordship. The refusal order 17, my lordship. With the reference cited above, the orders refusal registration in respect of the pending document.
Please see refusal order.
17 to 19, my lordship. 19, my lordship, I read, my lordship. This is a sale deed executed by the Ranganadam Saravantamurthy, the Pillikonda in favor of the Madam Thiru Vengalam, the Vengalachari Revatatam Matam Ramaswamy, consisting of the property that plot number, bearing number 1191, admeasuring 100 square yard, survey number 348, 351, 352, part and 357, part 358 were situated as Asbestos Colony, Jagadir, Kukatpalli Mandal, GHMC, Kukatpalli Circle. So and so as seen that the subject matter, whereas originally the government have allotted the land admeasuring 52 acres, Hyderabad Industries Limited, wide 923 revenue use to department dated 1/8/86 for providing residential accommodation to the 1364 workers as per the list already submitted to the government. And from this is very clear the Hyderabad Industries Limited is only competent
Have you
to
preferred appeal, Mr. Counsel?
Yes, ma'am. Similar conditions, my lordship. Appeal is filed by the another person, my lord. Appeal page number 96 to 97, my lordship.
What happened to the
That is allowed, my lordship.
appeal is allowed?
Yes, my lordship. 96 to 97. Even then, not register the document, my lord. I approach this honorable court in that case, and this court is given a direction, my lordship, to register the document. My lordship. The appeal number 8 of 21, my lordship. Party Elmal Srinivas and Elmal Kondaya and so and so. Child as sale deed, my lordship, executed the final 97, my lordship. As verified by the document, the property referred is house bearing number so and so, build up area is 100 square, admitting so and so, plot number is 1014, my lordship. Survey number, same survey numbers, my lordship. 348, 351, 351, 352P, 357P, 358P within the approved layout 6704 so and so situated asbestos colony, Kokatpalli village under GHMC, Kokatpalli Mandal, Medchal, Malkaji. On scrutiny of the document, it is found that the government has issued GO employed to Hyderabad Industries Limited for the residential accommodation that the employee GO 923 dated 1/8/96. The document executed as per the rights of the vendor who was the employee of the Hyderabad Industries Limited, and as such the allotment letter was also been provided to the vendor. Thus the appeal is allowed, setting aside the refusal order.
Letter?
My lordship, in my case, my lordship, the allotment letter 17 to 19, my lordship. Allotment 62, my lord. Sorry, my lordship.
Mr. GP?
Also, and registered the my lordship, in similar conditions, my lord, this honorable court is allowed, my lordship, page number 158 onwards, my lordship. I filed 2-3 order copies, my lordship. 154 onwards, 158 onwards, same survey number, same, my lordship. 58, my lordship. To 167. 3 order copies I filed in same survey number, same sub-registrar office, and same locality and Huda approval layout, my lordship. Allotted by the Hyderabad Industries Limited, my lordship.
Let them get instructions, Mr. Council will grant.
158 onwards.
And HEP first.
Forty-four, 45, and 46, same, my lordship.
To represent RR Kalyan.
My lordship, 2 are different, my lordship. Another 2.
Let them get instructions, Mr. Council. Let the GP get instructions, Watson.
Yesterday, all the matters.
Yes.
Post on long date, my lord. Just filed.
2 weeks we have granted. Yes.
Like permitted to withdraw liberty to file fresh mail yesterday matter.
But council, but the petitioner seeks permission to withdraw the petition with the liberty to file a fresh one. Granting such liberty, subject to the provisions of law governing the case, the petition is dismissed as withdrawn.
In the previous occasions, also counter not filed, my lord. That is why the honorable court is part of the orders.
Let us see, Mr. Council. Yes.
1 week, my lord. Over.
Let them get instructions, Mr. Council.
The petitioners are thoughts, survey number 69 of Tukpal village. And they are desirous of selling their plots, but the registration of the registrar that is not entertaining the hearing from.
Counter affidavits fine.
Which has been set aside by the court, and you are also with an identical case in page 33. The justification on the basis of which the sale deeds are not entertained and registered is dated 9th February 1989. And that was subject matter of the judgment at page number 33 in respect of another property. The order starts at page 33. And the operative portion of the order is page number 42. Paragraph number 1. Considering the fact that the notification published in the Gazette dated 9th February 1989 was set aside by this court is of the view that the registration authority cannot again place reliance on the same notification and refuse to register the document. Therefore, the reduction is imposed now to the following elections.
Yes, Mr. GP, the standing counsel. Again is this order.
is in from the similarity of
Huh? Huh?
This case we have found. Probabilities case has been first Supreme Court that what put it in the real. I do not know how to file the appeal against Supreme Court judgment. Other cases. Can you see the judgment of your lordship that page number 30? Paragraph number 4. The order that is referred to by the 11th Indian Council of Practice is rendered by this court in big authority and other from government on the place and the price in which the redwood shall WP double to survey, etc. The deciding those redwood shells dealing with the notification published by the board on the other dated 9 February 1989, this court had paragraph has held that extended portion of the keep and kindly go to page 40. Thus, this court, in the aforementioned decision, has given a clear finding that the notification published by the board to the other dated 9 February 1989 is not valid. That your Lordship, and despite of the objection by the standing public by the court, paragraph number 9. On the other hand, the submission of the letter standing to that the notification dated 9 February 1989 was sent by the court in view of the changing law, particularly the subsequent amendments to the law act, which are carried out in amending Act number 47 dealing with the effect of 3 2003. Subject property.
Yes, let them file their counter, Mr. Counsel. We'll see. Yes. This is in respect of 36 plots, not a single plot where we can dispose of. Let the counters, if any.
But the first is part of special. You don't
Yes. GP for finance. Why you could not get, you are not releasing the amount and you are not getting the instructions? Huh? Lund, GP for finance and planning and huh? Let us see after completion of list. Learned GP for forest seeks time to file counter affidavit. On the other hand, learned counsel for the petition of projects urgency. Full stop. Hence, counter affidavit, if any, be filed within 2 weeks. No further time will be granted. List on. Not first time. 23/8 and 27/9. List on. 29/11. First.
Finished by the. If you are not the summary. So it also some years to take. So it was 64. Both.
Where is the surveyor's report?
State charge is money. Now, no report has been furnished by surveyors.
Yes, GP for endowments.
In Mayor on survey, the survey currently stated that 77 by A is there, and I have written by six. And in second November, not intimated to go to by a for the new supply, but they go to try to move by state. What is the film that they are currently filming? When people come to bar. Try to elect this board. Not calling you for the plan. 21, 22, 23.
Yes, Mr. GP.
Of this cost of action. The main cost of action, again, that's the lordship, because we used to pass an order to practice appeal in the market. Based upon the class, they have filed their contempt and they place the copy is not enclosed. It's also closed with an observation that now the first observation order was complied. This was the contempt case which was filed. Which is the dispute of the petition has been disclosed the direction. The contempt of course, and now the instructions. Actually, the survey number 77 by 8 minutes. As per the deeper minutes, there was only a land instead of 1 acre 7 groups. In fact, when the survey was conducted, based on the orders, the total extent of land which is been encroached by the British is a 1 acre 14. 7 gurtas is excess to the what is there, what it should be there in the survey number 7. And based on merits as per our 43 register, and as per the people in the survey number 78, there should be a land clear extent of 32 gurtas. Plus, as per the village structure, it shows only 25 gurtas. This category is clearly evident that matters 7 gurtas have been enforced by the British. And these are the reports submitted by us. Take the lordship with the material papers.
You file your counter, Mr. Counsel.
77 plus 1 acre 26 gurta. Whereas the survey report is not 1 acre 14 gurta, as per the 10 lakhs. Whereas in the people, so 1 acre so. And the science team are page 64. Page 64, both the sketches are there. That was completely so both difference and as well as the case map is there, that is 764. Page 64. Page as per the survey, case map, as per the village map, it is in that. It is in that, and it was given by the informed to the by the surveyor. This 77 by is there. Can you see that?
Let them file their counter, Mr. Counsel. We'll order you to maintain status quo. Heard as responsible and counsel for the petitioners. Admitted. These are in respect of what?
Same, 25
Land Council for the petitioner seeks to list the matter on 14 level. Hence stand over to 14 level by order. Yes. You also find out a way, Mr. Council, in the light of the judgment of the division bench. You find out a way so that we can, if we dismiss the writ petitions, the registration done would go.
The petition cannot be dismissed because in these cases, the publication was issued relying upon the old act, which was struck down by the Honorable Court. The judgment which has been written by the division bench is relating to the new act enacted under Act 19. Whereas in all the cases which have filed, which was struck down by the Honorable Court in Pramadevi case. So petitions have to be allowed.
Yes.
I'm asking for file forward counter.
Yes.
So that they can be disposed of.
Yes.
Yes.
Yes. Order by tomorrow. Yes.
The same answer. So other matters, the lordship has considered the view of the direction not having power in respect of particular key. And also that the division bench strengthened with regard to the question they are raising 22 years session.
22A to D.
Yes.
Collector is having power.
Yes.
22E. Collector has no power. It should be a notification has to be issued by the state government.
And one more thing, who has to decide whether the property trust is also settled by the Honorable Court where there is approved and approved interest is there. The party disputes, but they not decide its own title. That is the properties which are they themselves issued a notification by the state government. Now they cannot say that it comes to the well.
No representation on petitioner.
Same match.
No representation on petitioner side on call. To give fair opportunity list on 1912. Same as in just no representation on petitioner side on call. To give fair opportunity list on 2012. Yes, Mr. Council.
What possible arbitrate? We try to for that. What was possible arbitrate?
This is not in respect of passing of award, Mr. Council. No representation on petitioner side on call. To give fair opportunity list on 1611. No representation on petitioner side on call to the side of 1912. No representation on petitioner side on call to give fair opportunity list on 19. తీసుకుందాం. ఎక్కడ కనెక్టెడ్ మ్యాటర్స్ అండి, ఏం చూసి ఇస్తున్నారు? ఈస్ట్ మార్కెట్ పల్లివి దీనికి అసలు కనెక్టెడా? ఏం చూసి ఇస్తారయ్యా మీరు? రిప్రజెంటేషన్ పిటిషనర్స్ అనుకుంటే పేర్ ఆఫ్ డీటెయిల్ లిస్ట్ ఆన్ 19th ఇంటరిమ్ ఆర్డర్ లేనాటివి ఏమని చెప్పండి. ఇంటరిమ్ ఆర్డర్ లేనివి పిటిషన్స్ వేయించండి రేపటి నుంచి. No representation on petitioner side of account. Give paid opportunity list on 19th. Same goes for same. No representation on petitioner side of account. To give fair opportunity list on 13th. 84 to 19. Same. No representation on petitioner side on call. To give fair opportunity list on 1611. Interim orders ఉన్నాయా? No representation on petitioner side on call. To give fair opportunity list on 13th.